Hi, I'm a lawyer practicing in India. My work doesn't involve too much foreign law. I don't therefore get too much of an opportunity to engage with it either. However, the United States Supreme Court last week handed down a judgment in a case called Dobbs versus Jackson Women's Health Organization. This decision was on an issue that Americans feel very strongly about: abortion. Americans identify themselves either as pro-choice or pro-life. The pro-choice people argue that a woman must have the right to choose whether to have her baby or to terminate the pregnancy. The pro-life people argue that abortion should be discouraged as it essentially brings an end to the fetus's life. This judgment in Dobbs' case set the American media and also American social media aflutter. So I thought I would use it as an opportunity to introduce myself to the American law. I also thought it presents an excellent impersonal opportunity for Indians to learn about how to think law, how to interpret the law, and how to read law and legal language. Anyway, here's some of what I learned. Remember, however, that this does not constitute professional advice or opinion. Before we come to abortion itself, let's take a look at two concepts: rights and precedent. Let's say I go to my neighborhood sports shop and pay the shopkeeper 350 rupees to buy a leather cricket ball from him. He takes the money and agrees to sell me the ball. But he says he doesn't have stock right then and will drop by my house later that evening to give me the ball. I agree. Now I have a right to receive the ball from him, but this is a right I have only against him and not against the rest of the world. Also, it is a right that arose from my agreement with him. It is not a right that the law created independently. It is merely a contractual right. The law, of course, is bigger and superior to our agreement and can itself create and destroy rights. The lowest or weakest form of right, in fact, is thus a right that you and I create between ourselves, like a contractual right. So, if by that evening there is a new law that prohibits the sale of cricket balls, my right will simply disappear. But let's assume that everything went well and that he came by and gave me the ball later that evening. Now that the ball is mine, nobody else can play with it, nobody else can take it or hold it or use it unless I permit them to. This is because I am the owner of the ball. And I suppose this is why the guy who owned the ball in school always was the most politically powerful. So now these rights I hold are not held against any specific person, but they are against the world at large. I held my first right to buy the ball only against the shopkeeper, but my ownership of the ball is a right I hold against the whole world. Here too, if suddenly a law is made that prevents me from owning cricket balls, my rights would again simply disappear. So as I said, the lowest or weakest form of right is a right that you and I can create between ourselves, like a contractual right. Then there are slightly more powerful rights than this. If I have a driver's license, for example, I have a right to drive a motor vehicle. This right is not created by some agreement or contract that I had with somebody, but by the law itself. It is not a contractual right, it is a statutory right. So a contractual right is somewhat private and interpersonal. People create these rights amongst themselves all the time. But a statutory right is more public, it is bigger. The law creates it for you and gives it to you, and quite often it does this whether you asked for it or not. Can there be a right then which is even more powerful than a statutory right? Yes. In India, we have constitutional rights, amongst which some are called fundamental rights. These fundamental rights are so strong that no law can be made to take them away. So if you can prove that a law takes away your fundamental right, you can get the law struck down by a high court or by the Supreme Court. So then there is a hierarchy of rights: contractual rights, statutory or other legal rights, and constitutional rights. And this is broadly the same position in most countries, including India and the USA. That brings us to the second concept, which is precedent. Let's say that the Supreme Court has held that buying cricket balls is a fundamental right. If tomorrow a law is made to prohibit the sale of cricket balls, a court can hold that the law is invalid as it violates a fundamental right. Once the superior courts have taken a particular view, then every governmental authority, and also you and I as normal citizens, are bound to act only in accordance with that view. It actually doesn't even stop there. The courts themselves are expected, usually but not always, to follow the same reasoning in subsequent cases too. This is what the doctrine of precedent requires. Therefore, once, say, the Supreme Court has held that a law banning the sale of cricket balls is unconstitutional, no other court can take a different view. If the government makes yet another law to the same effect, not only will the courts simply strike it down again, but this time they won't even be required to build the reasoning from scratch. The courts can simply rely on the earlier decision and blindly follow it. The doctrine of precedent permits this. Why does the doctrine of precedent exist? If the law has to work, it has to be uniform and certain. If the law keeps changing, nobody will know what the law is and there will be chaos. The law is often complex. It is sometimes also ambiguous or unclear. Lawyers are also, cheeky and creative as a bunch of people. So there is always more than one way to understand the very same words in the law. So if one court today interprets a provision one way and another interprets it differently tomorrow, there will be chaos. The doctrine of precedent ensures that there is consistency in interpretation. It promotes certainty in the law. Now finally, let us discuss abortion in the United States. In the 19th and 20th centuries, various states in the US enacted laws either restricting or prohibiting abortion. These laws would typically say something like abortion is not permitted except if it is necessary to protect the health of the mother. Therefore, everybody in the USA presumed that the right to abortion was not a constitutional right, but merely a statutory right or a simple legal right. Therefore, if a law was brought in which prohibited abortion altogether, the legal right was taken away and simply disappeared. In 1973, all this changed in a case called Roe versus Wade. In that case, the United States Supreme Court said that abortion was a constitutional right. The effect of this was that states could no longer make laws that would take away this right. However, the US Supreme Court also said that this right was not free of restrictions. How then would it create a balance between the right on the one hand and the restrictions on that right on the other? The Supreme Court formulated a scheme. It said that until the first trimester of pregnancy, the state would have no right whatsoever to interfere, and the question of whether or not to abort must be left to the medical judgment of the pregnant woman's doctor. For the stage thereafter, the state can regulate abortion, but it must be only in the interests of the health of the woman. The court also drew another line at viability. Viability is that point at which the fetus is presumed to be able to survive outside the womb. The court said that after viability, the state can regulate or even prohibit abortion altogether, except where it is necessary for the life or health of the mother. Therefore, in the first trimester, the state simply can't do anything. After that, the state can regulate but not prohibit abortion, and such regulation must be for the health of the mother. And after viability, the state could both regulate and prohibit, except where the life or health of the mother is in danger. Next came the case of Planned Parenthood versus Casey in the year 1992. Here the Supreme Court agreed with Roe versus Wade to the extent that it held that abortion cannot be prohibited before viability. It also disagreed with the trimester scheme and said that states were forbidden to adopt any regulation that imposed an undue burden on a woman's right to have an abortion. Therefore, it recognized the constitutional right to abortion like Roe did, but it modified the extent and boundaries of this right. That brings us to last week's judgments. In Dobbs, this court has simply held that there is no constitutional right to abortion at all. It has held that the Constitution mentions neither abortion nor anything related to it. It said that there would be no way to fairly derive a right to abortion as a constitutional right from anything in the text of the US Constitution. The court saw its function as interpreting the text of the US Constitution and thought that to read a right of abortion into the Constitution would be to add something which is not there at all. The court therefore said that there is no constitutional right to abortion, but left it instead to the states to create such a right, or on the other hand, to restrict or prohibit abortion. It thought that this was a function which was best performed by the legislature. The court thought it did not have the authority to go so far as to interpret the Constitution as creating such a right. The court takes the view that there are compelling interests from two sides, the women's interest being her right to choose, and the state's interest to protect the mother's health and life, and also to protect potential future life in the fetus. It states that the question of how to balance these two interests must be a question of policy, and that it is not within the authority or power of the judiciary to make those decisions. The court concludes that this balancing act to find a correct and appropriate policy must be left to the people acting through their elected representatives in the legislature. The court noted that different people may evaluate these interests differently. It held that people's elected representatives cannot be prevented from deciding on how abortion should be regulated. The court held that the Constitution and the court itself are neither pro-choice nor pro-life, but simply neutral. Essentially, therefore, the court said that the decision on whether or not to regulate or prohibit abortion must be taken by the legislature and not the judiciary. Having gone through all this, and I hope you're still with me, let us see what the court did and did not do. Has the court held that abortion is illegal or unconstitutional? No. Has the court held that there is a constitutional right to abortion? No. Has the court held that there is no legal right to abortion? Again, no. So what has the court done? It has said that there is no constitutional right to abortion, but that the existence and extent of the legal right is to be determined by the legislature and not by the judiciary. Was the court right in what it did? You see, I want to draw a clear line of distinction between facts on the one hand and my opinions on the other. I only want to give you the facts, and I want to try not to give you my opinion. So I won't tell you whether I think the US Supreme Court was right or wrong. I won't tell you whether I like what it did or don't like what it did. But I do hope that with this information, you will be closer to forming an informed opinion of your own. I hope you enjoyed this, or at the very least found it useful. Let me know if you'd like me to do more videos like this. Let me know if I can change anything. Let me know if you want me to cover any particular subjects. If I do end up doing more videos like this, it will likely be on the Indian law or legal theory in general. But I make no promises that I will make more such videos. In any case, thank you for staying until the end.